Most people are familiar with the issue of sexual harassment. While many employees often joke about the issue, it is a very serious problem for employers. The number of sexual harassment cases reported each year to the Equal Employment Opportunity Commission, EEOC, is alarmingly high. Sexual harassment can be very detrimental to the company, its employees, and to the employee's family and friends. As managers and supervisors, it is extremely important that you understand the definition of sexual harassment, the types of sexual harassment, potential victims and harassers of sexual harassment, effects of sexual harassment, your company's policy regarding the issue, ways to prevent sexual harassment, investigative procedures of a sexual harassment case. With the passage of the Civil Rights Act of 1964, the agency known as the Equal Employment Opportunity Commission, EEOC, was created to promote equal opportunity in employment through administrative and judicial enforcement of the federal civil laws. Title VII of the 1964 Act prohibits harassment of an employee based on race, color, sex, religion, or national origin. While the EEOC addresses these various forms of harassment equally with the same guidance, this training program will only cover the area of sexual harassment. Sexual harassment is defined as any unwelcome sexual advances, requests for sexual favors, and verbal or physical conduct of a sexual nature when submission to this conduct is made either explicitly or implicitly a term or condition of an individual's employment. Submission to or rejection of such conduct by an individual is used as the basis for employment decisions affecting such individual. Such conduct creates an intimidating, hostile, or offensive work environment. Two types of sexual harassment are generally recognized: quid pro quo and hostile work environment. Quid pro quo. This is the more obvious and easier to identify form of sexual harassment. The term quid pro quo basically means something for something. This type of sexual harassment occurs mainly between a supervisor-manager and a subordinate. A supervisor is anyone with the authority to undertake or recommend tangible employment actions. Tangible employment actions include things such as hiring, firing, promoting, demoting, and reassigning. Directing an employee's daily work allows for a supervisor to increase or decrease an employee's workload, or to assign tasks that are demeaning and undesirable, or favorable and desirable. With quid pro quo, sexual conduct becomes the grounds for employment decisions. The supervisor-manager tells an employee, "Spend the night with me and I'll give you a pay raise." The reverse would be, "Don't spend the night with me and you will be fired." Quid pro quo sexual harassment is much easier to define because it is more obvious. Hostile work environment. This type of sexual harassment is more difficult to define, but the majority of sexual harassment cases fall under this category. Comments or conduct based on sex, sexually oriented material, or other offensive material is considered harassment when they unreasonably interfere with an employee's work and are unwelcome, severe, or pervasive. The comments or conduct are also considered harassment if they create a work environment that is intimidating, hostile, or offensive. Single or isolated incidents of sexual misconduct generally do not create an environment that is considered hostile. A hostile environment claim usually requires proof of a pattern of offensive conduct. The more severe the harassment, though, the less the need to show a repetitive pattern. To be considered unwelcome, severe, or pervasive enough to constitute sexual harassment, the activity must also be serious enough that a reasonable person would find it offensive. Many actions are considered, or could be considered, forms of sexual harassment. Such actions include, but are not limited to, staring or leering in a suggestive manner, making offensive remarks about someone's looks, clothing, and/or body, touching, pinching, patting, and/or brushing against someone in a manner that creates an uncomfortable feeling, telling sexual or offensive jokes or making sexual gestures, displaying sexually related material such as posters or calendars, sending sexually related material via emails, letters, or notes. Victims and perpetrators, harassers of sexual harassment, can be male or female. Harassment can occur between people of the same sex, male to male or female to female, as well as people of the opposite sex, male to female or female to male. Harassment can also occur between other than just a supervisor and employee. Harassment can come from a coworker, outside contractor, sales rep, vendor, or delivery driver, just to name a few. Employers can be held responsible for acts of sexual harassment by employees as well as non-employees when the employer knows or should have known of the conduct and fails to take immediate and appropriate corrective action. For this reason, companies should take a very proactive approach to preventing harassment from occurring. A strong sexual harassment company policy that encourages affirmatively raising the subject, expresses strong disapproval, outlines actions to take in harassment allegations, provides for appropriate disciplinary measures, and develops methods for sensitizing all affected people should be established. Victims can be someone other than the intended target of harassment if the other person was affected by the harassment. When an employee is given a promotion, transfer, or other benefit in exchange for sexual advances or request for sexual favors, quid pro quo harassment has occurred. Any employee that was qualified for but denied the promotion, transfer, or other benefit because of the sexual harassment could also claim sexual harassment. Sexual harassment can do great harm to an individual, their family, co-workers, and the company. There is a great amount of guilt and shame that victims wrongly feel. Stress, anger, frustration, helplessness, depression, and hopelessness are other emotions that victims might experience. The family of the victim can also have many of the same feelings and problems that the victim experiences, either as a direct result of the harassment or due to the family member having to deal with the harassment. Many other negative experiences are possible, such as financial difficulties, physical ailments, and relationship problems. Sexual harassment can also be harmful to the company. Harassment can have the same emotional and physical effect on the victim's coworkers as it does on the victim. In addition, employee morale generally declines, productivity can suffer, the reputation of the company can be compromised, and financial burdens can be incurred due to lawsuits and settlements. Every company should have a very thorough policy concerning sexual harassment. The policy should be designed to encourage possible victims to come forward and should not create obstacles to complaints. Prevention should be the primary goal of the company policy, and it is the best method to eliminate sexual harassment in the workplace. The policy should contain a clear definition of sexual harassment, strong statements that communicate to all employees that sexual harassment will not be tolerated, standards for employee dress code, workplace behavior, and personal belongings, pictures, calendars, magazines, etc. Statements assuring employees that the company will take immediate and appropriate corrective action whenever harassment has occurred. Names of appropriate personnel and departments to which employees can report possible harassment. More than one person should be designated to take complaints. Statements assuring that the employer will protect the confidentiality of harassment complaints as much as possible. Language informing all employees that any form of retaliation against someone that brings a harassment charge or provides information will not be allowed. Complaint or grievance procedures that provide a prompt, thorough, and impartial investigation. Remedies for the victim as well as disciplinary actions for the harasser. Corrective procedures to take to minimize any recurrence of the harassment. Some companies prohibit romantic relationships in the workplace. Sexual harassment is the main reason why. Even though such relationships do not constitute harassment, they can be misunderstood by coworkers and management. It can be difficult to know if an employee is in the relationship willingly, out of fear of retaliation, or because of special treatment, something for something. Additionally, when workplace relationships end, one person could become bitter and claim sexual harassment, or one might wish to continue the relationship, and their persistence in pursuing the relationship would be unwelcome. Regardless of your company's policy, it is still a good practice to discourage workplace relationships. Along with creating and distributing the company's sexual harassment policy to all employees, employers should ensure that all supervisors and managers understand their responsibilities under the company's sexual harassment policy. Additionally, employers should initiate other measures to prevent sexual harassment in the workplace. Education and training are essential tools for preventing sexual harassment. The use of training videos, booklets, workshops, posters, peer groups, and seminars are just a few possible options to use for educating and training. As a member of management, you should set the example for all employees. Your dress, actions, language, and relationships will be scrutinized by those you supervise. Follow your company policy and keep your actions above reproach. Being proactive and keeping the subject of sexual harassment a current topic of discussion helps reinforce the company's prohibitive stance against sexual harassment. Strive to be a positive example in every aspect. When allegations of sexual harassment are made, a prompt response is essential. Employers should determine if a fact-finding investigation is necessary. For instance, if the alleged harasser does not deny the accusations, then the investigation would not be necessary and corrective action could be immediately taken. If a fact-finding investigation is necessary, it should be launched immediately. The amount of time needed to complete the investigation will depend upon the particular circumstances of the case. Intermediate corrective measures to stop the unwelcome actions should be taken, and the well-being of the alleged victim must be secured at the very start. Steps such as scheduling changes, transfers, and placing alleged harasser on non-disciplinary leave with pay are some possible intermediate measures. The complainant should not be involuntarily transferred or burdened. The main steps of a fact-finding investigation are: choose an investigator, conduct interviews, determine credibility of interviews, gather any additional information, make determination of harassment case, apply appropriate corrective and disciplinary measures, maintain records of the investigation. The employer must ensure that the investigator in a sexual harassment investigation is objective and trained to properly gather all facts. The alleged victim and harasser should have no supervisory authority nor any direct or indirect control over the investigator. The investigator must also possess skills necessary to evaluate credibility and to interview all parties involved. While each investigation should be adjusted for that particular case, it is still necessary to conduct interviews. The following are some of the possible questions that should be asked of that person. Alleged victim: what occurred? Who committed the alleged harassment? When and where did the harassment occur? How often has the offensive behavior occurred? How did it affect you and how did you react? Has your job been affected? Were there any other people present when the incident occurred? Are there any notes, physical evidence, or other documentation to support the harassment claim? Do you know of any other pertinent information? How would you like to see the situation resolved? Alleged harasser: what are your thoughts about the allegations? Why would the alleged victim make such claims? Are there any notes, physical evidence, or other documentation to refute the claim? Were there any other people present when the incident occurred? Do you know of any other people with pertinent information? potential witnesses and other parties. What did you see or hear? When and where did the incident occur? Describe the alleged victims' and harassers' behavior towards each other. Do you know of any other pertinent information? Are there any other persons with information about the case? Many times, the interviews will produce conflicting versions of the incident. The investigator will need to determine the credibility of the various parties, and his/her assessment can be critical in determining if the harassment occurred. Some factors and relevant questions the investigator should consider include: inherent plausibility. Is the testimony believable? Are there any contradictions in the facts? Behavior. Did the person seem to be telling the truth? Incentive. Did the person have a reason to lie? Verification. Is there any testimony or physical evidence that confirms the person's statements? Employee file. Is there anything in the person's employment file to show similar behavior in the past? While these might be helpful in determining the credibility of persons involved, they should not be the sole determining factors in credibility of the harassment case. The investigator should gather any additional information that might help in the case. Items such as employment records, work schedules, time records, and emails are just some of the possible information that could assist in verifying facts of the case. Once the investigation has been completed, the employer must make a decision as to whether sexual harassment occurred. All parties involved should be notified of the decision. If due to inconclusive evidence and/or contradictions between parties, no decision is possible, the employer should still take preventative measures as a precaution and to reinforce the company's policy on sexual harassment. If harassment has been determined to have occurred, employers must take appropriate actions. Corrective measures should be designed to stop the harassment, ensure that it does not happen again, and correct the effects on the employees. The corrective measures taken do not have to be those that the victim requested or preferred, but they must be effective. Disciplinary action should be proportional to the seriousness of the incident. Minor issues might only warrant such disciplinary actions as an oral warning and retraining. If the harassment was severe, then stronger discipline would be necessary, such as suspension and/or termination of employment. Employers should remember that if the harassment does not stop, they could be found liable, but that overly punitive measures could be grounds for additional legal action by the harasser. Employers have to make sure the punishment fits the crime. Possible disciplinary actions include training, oral and written warnings, wage reduction, demotion, transfer, suspension, and termination of employment. Measures taken should not affect the victim negatively. Corrective measures taken that penalize the victim could constitute unlawful retaliation. Corrective measures should be utilized to right the effects of the harassment on the victim. Measures should be designed to place the employee in the position he/she would have been had the incident not occurred. Examples of such measures might include an apology from the harasser, reinstatement, promotion, wage increase, replacement of time taken off, and correction of any other effect caused by the incident. A written report should be kept of the investigation. All files should be kept confidential and only authorized personnel allowed to see them. These files might be needed should future harassment charges be alleged. This video training program has provided you with important information about sexual harassment in the workplace. As part of the management team, you must take sexual harassment seriously. Utilize the training and education programs provided to you to prevent harassment in your workplace. Watch for indications of harassment among your employees. Discourage behavior that could lead to sexual harassment allegations. Take action immediately if sexual harassment has been alleged, correcting the problem quickly and ensuring the situation is properly handled. Everyone in your company will benefit from a workplace free from sexual harassment.